Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, welcome to another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman, and this afternoon we have Dennis Raglin from the law firm of Steptoe. Welcome to the show.
Thank you. Glad to be here.
Absolutely. Latte with a Lawyer, first question, what's your morning beverage of choice or afternoon? How do you get started during the day?
Well, it's not with a latte. I start with a Diet Coke, and then probably 2 hours after that, I'm in a Red Bull. And then afternoon, probably a different type of Red Bull.
Very good. So people are still drinking Red Bull these days, huh?
Well, I call it Red Bull, but there's a ton of options, right? There's Monster, there's Bang. I'm quite a connoisseur of energy drinks.
Interesting. How'd you get hooked on that?
Diet Coke wasn't doing it for me, and I've never really liked the taste of coffee. And so this just kind of became the way to get caffeine into the blood.
There you go. All right, good. So good segue to how do you spend your day? What's your law practice about? Sounds like you need a lot of energy.
You do. I work in what I call chemicals. The best way to describe it to folks is we have a right to know warning law out here in California called Proposition 65. Anyone who's been in California has probably seen, they have signs and labels that say this product is known to the state of California to contain a chemical. So I represent companies who get claims of violations for those.
Okay. So kind of like I used to be in the construction business a long time ago, and super funds and hazardous waste and that kind of thing. Similar.
Similar to that, right? It's a government regulation that, in my opinion, is allowing, let's not say abuse, but let's just say a very liberal interpretation.
Okay.
Companies get caught up in this and they have to make a decision, even if they've got a good case to say, I'm not in violation. You have to decide on a business decision level, right? What is more cost effective? Do we settle or do we litigate? And in California, I'm sure your other guests have told you who've been from here, it isn't a very expensive place to try a case, and experts are expensive. And so you do see a lot of companies resolve these cases by settlement, even though they've got a good defense.
Right. Well, they also have to realize that if you take them to the mat, you're not afraid to do that. So therefore, they want to settle. Otherwise, you have to try some cases to get there, right?
That's right.
Yeah.
You don't see many trials in this particular type of law, because if you lose as a defendant, it's a plaintiff statute in the sense that you have to pay all their attorney's fees
Okay.
and their costs.
And
for example, I just had a trial that ended middle of last year. It took almost a year to try the case. Our client prevailed, but costs for our client alone, I was just preparing those, are over $400,000. And so you have to be, and that's on top of their own lawyer's fees, us, right? So you're looking at, $1, $2, $3 million to try a case. And it's, the smaller you are as a company, right, the harder it is to make that decision to go forward.
Oh, sure. So can you talk about that case?
Sure. So this case involved rice, the product rice. Rice has been around for, I don't know, just a little while in our world. And so the plaintiff in this case alleged that the rice needed to have a warning for lead in the rice. And under this law, a warning is required only if the exposure to the person exceeds a set number that the state has in their regulations. For example, 0.5 micrograms a day for lead in California is your daily exposure ceiling. And if it's over that level, then you should have a warning. Well, our facts, our clients, our experts pointed out and were able to prove that the average exposure to this rice of lead was well under that ceiling. And so to do that, it's, as you can imagine, it's a very scientific-based type of defense, right? We needed a toxicologist. We needed a food scientist. They had to do some calculations. And I'm simplifying it. It's actually much more complicated, right? But so after all that evidence, these are bench trials, Prop 65. After all that evidence.
These are bench. So these are not jury trials. They're bench trials.
These are not bench. They're not jury, they're bench.
Okay.
And so the judge basically acts, if you will, as an administrative agency. It considers these facts, it considers the science, and it determines whether your exposure has exceeded that level. And in this case, the judge found that it did not. And so I thought it was really fascinating for a couple of reasons. Very few of these cases go to trial, like I said, because of the cost. This particular client had the money to do it. And by settling and deciding to put a warning, it would have upended the rice industry. Can you imagine walking into the store now and suddenly all of these warnings, a product that's been around for 2,000 years or so is suddenly now quote unquote dangerous. So it was a big deal for the client, a big deal for the industry. But you learn a lot in these trials. And I'm sure some of your guests have talked about how there's nothing like a trial to really put you to the test.
Right, exactly. So how do you prepare for those kind of trials?
You gotta not just prepare, but you've got to learn the science. If you told me when I was in high school that I would be talking about exposure to rice, you would have been, I would have said you're crazy. But that's what you have to do in these cases. You have to understand as best you can, soup to nuts, in terms of what is exposure, how do you calculate it, what's the average user, what's the average amount they eat. And so those were very foreign to me coming from a political science background. But for a trial in this type of case, you need to be able to go toe to toe with your experts and understand where they're going, because your job as the lawyer is to then explain it to the judge what this all means. And as you can imagine, many of these judges don't have science backgrounds.
Sure.
And because so few of Prop 65 cases go to trial, many of the judges here have never had a trial in that area. So it can be very complicated. And so to your point about preparation, you need to go that extra mile and put your science hat on best you can.
But if you have a judge, again, who's not used to administering these trials, and all of a sudden they get this very technical case in front of them, I mean, how are they qualified to come to a conclusion there?
That's a big debate. Some of them are not. And in fact, one of the arguments for this law is, against this law is, you're forcing a judge to, like I told you earlier, to be a government body, right?
Yeah.
And decide what the level of exposure is. So we could have 10 different judges. You could have 10 different ways of looking at the case, right?
Sure.
And so that's one of the arguments that really calls into question whether this law is constitutional. That's a whole nother argument that some defendants are making on a couple of different grounds. So far, no judge has really in California said that this law is unconstitutional, but there are challenges to it in the last few years, and that may be something that we see in the future. But you can have different judges, different opinions, and it's very risky to go to trial. Again, another reason it's risky is because just because Judge A said X doesn't mean Judge Y is going to say the same.
Right. Yeah, interesting. So that's one example, rice. I mean, that's probably your first and maybe last case involving rice, I would imagine.
Yeah. It's all kinds of products, all kinds of food.
Yeah.
I've had baby formula. Mothers aren't going to like a warning on that baby formula saying that this can cause, reproductive harm or cancer.
Sure.
And so, the client in that case said, no, we're not going to put a warning on that. We're not going to scare mothers. We're not going to stop babies from getting nutrition. And so they went to the mat on that one as well. So you can have food, you can have products like, drinking glasses, eyeglasses, automobiles, smoking. I mean, it just goes on and on. 950 chemicals are on that list of chemicals that you can have a Prop 65 warning.
Okay. Oh, they all fall under the Prop 65. Okay.
That's
Is
right.
that, is that just a California?
Yeah.
Okay.
But even though it's just California, we're kind of a big market, right? And so
Sure.
companies all over the world, if you want to sell product here, have to comply with that.
Okay.
And so you're seeing kind of a worldwide requirement to sort of comply with this or put warnings on or reformulate your product so that exposure is under that ceiling because it's such a big market. People don't want to give up California. And so they're trying to adjust and have been over the last 20 years, trying to adjust to that reality and comply.
Got it. Okay. So how'd you get started? How'd you get into this line of business? What's your background and path to get here?
If we go back to high school and you told me I would have been into this type of law, I would have also said you're crazy. It started with a colleague of mine at a former firm. And, I had some time and she said, well, I need you to help me on a couple cases. This was probably 15 years ago. And I said, all right. And it started there. And then she had more cases, and suddenly I was getting knowledge about it, and I started getting my own clients in it. And then it just grew from there to the point now where it's the majority of my practice. So I guess the answer would be by happenstance, right? Like a
Yeah.
lot of your guests have probably said, I didn't set out for this, but it came to me, and it just kind of snowballed from there. I got experience in it, or I was good at it, or I enjoyed it, and it just went from that point.
Got it. Just go back even further. Like, how'd you decide to become a lawyer?
So my thinking was politics. I had interned at the California State Senate. I'd always been interested in it, politics, California particularly. And my thinking was, I'm going to go to law school, and that's a stepping stone for politics. I didn't know if I wanted to do elective office or work as a consultant. Those are my general reasons for going.
Okay.
And then my daughter was born, and I thought, well, you have to make some money. And so then it kind of diverted from there to private practice.
Got it. Well, you can make a lot of money as a lobbyist, or,
Right.
getting involved with government too, I suppose.
Right.
And you're from California. That's where you grew up.
Yeah. Grew up in the Bay Area, and then moved down here about 5 years ago.
Okay. Anyone else in your family, lawyers? Any other people influence you along the way?
In terms of coming on up and influence, no. I was very fortunate to have some really strong teachers, both at high school and college, to help me make that decision. I'm the first of my family to go to college, much less law school. And
Okay.
so I was very fortunate to have those mentors coming up. And in terms of the second part of your question, there were no lawyers in the family until after me. And now I've got a nephew that's going, and then a niece who's a paralegal, and then another niece who's considering it. So I told my mom, you got a bunch of weirdos in this family, that the lawyerness is kind of too much, too clustered.
Yeah, that's funny. Why? What was your family background that nobody? Were you professionals, or what kind of work?
My mom was a administrative assistant for 40 years.
Okay.
And she met my stepdad when I was about 8 or 9. And I often tell people, without him, I wouldn't be here. He came in and really helped my mom when she needed it. Single mom of 2 boys.
Yeah.
And so, it was a humble beginning, let's say that. But they've been together now for, I don't know, almost 40 years. And so, things are good.
Oh, good.
I have him in my life, and they're both still kicking. So that's
Okay.
good.
Oh, excellent. Good. Very good. So what would you tell your kids? Would you tell them to pursue a career of law?
I would tell them to run as far as they can from the no, I mean, another thing your guests have probably shared with you, this is not an easy job, depending on the type of law you do. And especially in the litigation side, you take home that problem and you sleep on it, you marinate on it. It can intrude on your weekends. But that's the price of admission for what we do, right? I mean, by and large, most of us make a decent living in this type of work. And when your client's problem becomes your problem, you need to solve it. You need to come up with a way to get the client happy, save them money, find a solution. And so that really can be a double-edged sword. Sometimes you're kind of high on the adrenaline. You love working the case. You're getting ready for the trial. You're getting ready for deposition. The flip side of that is you can be on vacation and the client needs you. And what are you going to say? No. They're the client. They're paying you to solve their problem. So you're on call. Similar to a doctor, but we don't save lives. We, save money. If we
Got
can.
it. Yeah, I understand. No, I mean, listen, you have to have a lot of drive and passion for it, because you're right. It's not easy. But you guys are doing good work, and you're the voice of the client. So I'm sure that's what keeps you going.
Yep.
What other traits would you say make somebody a good lawyer, successful?
It depends on the type of law. For litigation, for example, you need to know your way around a courtroom. Even if you're not in trial, you need to be able to argue a motion. You need to be able to know what the procedures are in a specific court. And you need to think on your feet. And you need to be able to master the written word and oral. So you've got to be a jack of all trades in litigation and be ready for anything. But I think the biggest skills you really need are, you got to be a good writer. That's, I think, in my opinion, one of the best. You have to be a good oral advocate, which we would all assume if you're in litigation.
Sure.
But writing, again, becomes such an important part of what we do. And that's something, frankly, when I started, I didn't realize. But the critical part of a litigator's job is you need to be able to be persuasive and concise in your writing. If you drone on, if you use a lot of adjectives and things like that, you're weakening your writing. And judges here in California, many of them don't have research assistants, so they take home these briefs, they read them on their own, they make their own decisions. So imagine if you've got 50 briefs that you need to read over the weekend, you got to be able to grab their attention, concisely say what the problem is, say what you want them to do, and say why, in and out.
Got it. So how do you learn that? I mean, how do you learn those skills?
It's trial and error. I was not a great writer when I started out, and it's workshopping it, wordsmithing it. You have to spend time with it. And that's something I didn't appreciate at the beginning either. And the younger you are, the harder it's going to be, the longer it's going to take. But I have associates now who are writing kind of like I wrote at that level, and you have to learn it. You have to have someone like me tell them, this is what you need to do, this is why. That's the thing that younger associates may not understand. Okay, I've made my argument. That's all I need to do. Sort of. You have to think about the reader, and you have to think about what you want that reader to do. And going to my example, they're going to look at it for 2 or 3 minutes. If you want to drone on about this, that, and the other, you're going to have a weaker brief. So workshopping it, I guess the final point I would make on that is, if you can, sit overnight with it, right? If you have that luxury of time. And I have found out that after I sleep on something, it makes for a better brief, or it makes for a better document, because things that you were too tied up in when you were doing the first draft suddenly make more sense. So that would be the best advice I would give somebody if they have the time.
Got it. Yeah, no, I understand. I'm going to give you a suggestion. Far be it for me to give you a suggestion, but a book I was introduced to recently, and it's exactly as you're articulating it, Smart Brevity. If you haven't read it, is a terrific book. Smart Brevity. It's the genesis of Axios reporting.
Okay.
And it's all about just that.
Yeah.
Concise, compelling, no wasted words.
Nice.
And
the thing I would recommend to people is Brian Garner, I think, he wrote some books on legal writing, and he was really helpful. And that's something I recommend to my associates as well. But I'll look up this one.
Yeah, I think you'll like it. But it's funny. I was an engineering student, and I always wrote that way anyway.
Right.
And people used to kind of poke fun of me because it was like very direct to the point. But like that is really, with Twitter and all the, with so much data and everybody being a self-publisher, I mean, to your point, exactly. I couldn't agree with you more. You want to get to the point quickly. People have too much information. They're overloaded, right?
Exactly.
So I'm with you on that. What kinds of technology do you guys use in the firm to become more efficient?
There's a couple of different things. We've got a very good IT team,
Okay.
and we're good about we have a good document management system, which I think is important, because talking about overload, I mean, you've got to keep track of several different cases at once. Of course, you've got different PowerPoints, you've got different briefs, you've got different memos. And for me, I need a central place to find all of it and be efficient about it. So I will say the firm's got a good system on that. In terms of trial, for example, you need a good trial technician. And I didn't realize how important that was when I was starting out. But if you've got a case like ours with thousands of exhibits, you're never going to be able to do a good job unless you've got someone from the outside coming in, organizing it, and being able to call up the document, being able to know where you're going with an argument. And that's really instrumental to what we do.
Okay. Do lawyers use a CRM, like a Salesforce or something like that, to keep track of clients? Do you use those kind of platforms?
I don't know about that. I do know that we have specific lists for each practice group. So we keep our contacts, we add to that. So if we're, for example, having a webinar, We can choose which contacts to send invites to, who
Yeah.
might appreciate it. But in terms of the specifics from that, I would have to get it from marketing.
Okay. How many lawyers at the firm?
I think there's close to 300.
Okay, that's a pretty big law firm, and full service law firm.
Right. They do everything. White collar and regulatory was really how the firm started way back.
Okay.
It's DC based, and so as you
Oh,
can
you're
imagine,
DC based. Okay,
yeah,
interesting.
I'm in LA, which is one of the as I call it satellite offices. But I think we've got about 30 or 40 lawyers here now.
Okay, that makes sense then. Okay. And all defense mainly?
Yes.
Yeah. K Street in DC or something? I lived in DC for about 17 years,
Oh,
so I
really?
know.
I think it's on Connecticut Avenue.
Okay.
Yeah.
Yeah, nice. Have you been to DC? I'm sure you have.
A few times, yeah.
Yeah, it's a nice place.
I don't enjoy the winters, but it's a fun place to visit.
Yeah, the winters are no good. Go there in the spring, it's beautiful.
Right.
And yeah, it's a good city. Excellent. So what advice would you give a young lawyer coming up and starting? What would you tell
I think you need to, in my opinion, you need to not take yourself so seriously. I see that as an issue with a lot of lawyers, regardless of their level. If you can't laugh at yourself, in my opinion, something's wrong. You need to be able to look at this as a job, of course, but it's not life and death. Now, the asterisk there is, of course, criminal lawyers. That's different.
them?
But for non-criminal lawyers, this is not life or death. You don't have to go to war every day. It's
Right.
not a battle to destroy someone every day. You need to step back and look at it as this is part of my life, but this is not all of my life. And I see a lot of young lawyers make that mistake. They burn out early because they're afraid of their own shadow. They're afraid that they're going to screw up. Everything is serious. Everything is life or death. And you can't go on in a career for 30 or 40 years like that and be either happy or normal.
Right. Yeah, it's not sustainable.
Not sustainable.
Yeah, yeah, interesting. So do you have a bunch of associates working in your group that you're helping?
Yeah, we've got not a bunch, but we've got 3 or 4 that are kind of my solid go-tos.
Okay.
One of them I brought to trial with us. She did great, got a lot of experience. Stood up and did one of the direct examinations, and she'd never done that before. And you get so few trials here in California in particular, that was a good opportunity for her. And afterwards we sat down and we went through, okay, you could have done this better. I thought that was a great thing. That's how you build confidence, and that's how you can read every book, you can read every case, but nothing takes the place of sitting in front of that judge and having him or her grill you, or having to throw out the notes and go in a different direction. You have to think
Right.
on your feet, and the only way you really get that experience is by doing it.
Right. Right. Well, it's funny. I've had that conversation many times on the show with lawyers and asking, do you think it would make sense to maybe take the 3rd year and make that more of a transition into the real world as opposed to academic?
Yeah.
What's your view on that?
I agree completely. Again, out here, so if you go to trial, it's a skill that even if you don't go to trial, it's a skill you need to be an effective oral advocate. You can't sit in a room, reviewing documents for 3 or 4 years and be considered a litigator. And you stunt your development that way, and it's more difficult for you to come out of that mode, right? Perhaps you lose confidence in yourself. Perhaps you get your senses and your way you do things dulled and stunted. So I agree. There needs to be more of an emphasis on getting them out of those types of situations, putting them in the mix, whether it's a mock trial, whether the firm can do that type of thing, or sending them to an academy or whatever.
Sure.
But you don't do your associates any service, and you don't do your clients service if you're putting these kids in a room and not developing them. And it hurts their development, and it hurts the firm, and the client ends up paying for that in the long run.
Yeah, for sure. Yeah, interesting. Yeah, no, I was wondering, I mean, maybe a form of an apprenticeship, or, some practical application as opposed to reading,
Yeah.
studying cases.
Yep.
Because, right, you get out of law school and it's like, okay, now I have to be a lawyer. How do I do that?
That's right. Nobody teaches you that part.
Or especially even running the business, right? I don't know if
Right.
you're
Oh,
involved
yeah.
yet in the management, but it's a business too. You got to run that as well.
And you've seen some of them run it right into the ground. Some
Yes.
lawyers are not great business people.
Yes, that is very true. Anyway, good stuff. So just final words you want to leave with the audience about your firm and the best way to connect with you if they want to learn more.
Sure. I think the best way to connect with me is, shoot me an email, which is draglin, Raglin, at steptoe.com. So my first initial, last name at steptoe.com. I would give the final words would be understand that we are a business and understand that you need to, at whatever level, start thinking about business development. You need to start thinking, how can I market myself? Because you're the only person that can be the best marketer for your brand. Consider yourself a brand. How are you going to market it? It's never too soon to start. I wish I had started earlier. So my advice to people would be to start thinking about that and start doing. Look for ways to get yourself out there. Talk to people. How can I get in front of clients? Maybe I volunteer for something. You've got to start early. You've got to market yourself. This is a business. And eventually, the more business you have, the more valuable you are to the firm.
All right, good stuff. Thank you. I appreciate that.
Thank you.
For everybody, again, Dennis Raglin with Steptoe, and this is sponsored by EmotionTrac, which is a legal tech platform that helps litigators prepare for mediation and trials with our Insights platform. Thank you, Dennis. Appreciated the time with you today. Enjoyed it.
Glad to be here. Thank you.
You bet.